Hello, my name is Jordan Ramirez, and I'll be presenting the case Whirlpool versus Marshall. Over the years, Whirlpool, an appliance manufacturer, had incidents involving workers falling from a wire mesh 20 feet above the ground. Two employees who worked for Whirlpool providing maintenance throughout the factory noticed the weak structures and voiced concerns with their boss. The following days, the two workers were instructed to clean the wire mesh, which they refused to do due to safety concerns. After working just 2 hours at the factory, the two employees were told to punch out and were given written reprimands due to refusing to perform their tasks. The plaintiffs, being the Secretary of Labor, took Whirlpool, the defendant, to court, alleging the company's actions constituted discrimination under the Occupational Safety and Health Act of 1970, otherwise known as OSHA. The OSHA Act offers employees who believe their safety is at risk several rights while simultaneously protecting them from any discrimination that may arise while exercising those rights. Those rights include the right to inform OSHA of a dangerous work environment. Also, an employee may be allowed to a certain extent assist the OSHA inspector in assessing the conditions the employee claimed to be unsafe and help the court decide if there was any imminent danger. Lastly, if the secretary does not seek injunctive relief, the employee may has the right to take action against the decision. Along with the rights provided by the Act itself, the regulation created by the Secretary allows the employee to refuse to perform a task that would put them at risk of injury without any discrimination from the employer if no other alternative is presented. The district court agreed with the secretary about the discriminatory actions the employer took since the two employees refused to work due to genuine safety concerns that could have led to severe harm. Yet, the court denied relief compensation due to the secretary's regulation not being consistent with OSHA. The court decided that the regulation in question was inconsistent with the OSHA statute because, at the time, Congress was still trying to decide if employees had the right to leave work if there was a safety concern, which Congress decided against it. The case was then presented in front of the Sixth Circuit Court of Appeals, which overturned the previous decision made by the district court. The appellate court agreed that the district court's decision, with the district court decision, that there was enough support for the actions taken by the two workers, but disagreed with the conclusion that the regulation was invalid. Because of that, the petitioner argued that the regulation created by the secretary did not align with the intentions of Congress when the act was passed. At the time, two congressmen passed a bill rejecting strike with pay and instead allowing employees the right to contact an OSHA inspector. The petitioner argued that Congress rejecting the strike with pay provision was to prevent the employees from abusing the employer by walking away or refusing to work and ultimately still get paid, which they believe is precisely what the two employees did. The court believes that the regulation in question suits the act's objective, as it forces the employer to provide a suitable working environment free of any hazards that would place an employee at risk. When an employee feels unsafe, the act allows the employee to contact an OSHA inspector. Of course, there's not enough inspectors available for there to be always one present at each factory or business. Hence, the regulation allows for employees to remove themselves from the immediate danger to prevent harm. The court disagrees with the petitioner's interpretation of the regulation. Congress was concerned with strike with pay, giving too much power to the employees, forcing employers to pay full salaries to those refusing to work. Congress rejected strike with pay to protect employers against these actions and prevent such obligations by the employer. But either way, such interpretations are outside the scope of the question being asked in this case. The regulation in question allows the employers to remove themselves from danger and prevent them from receiving discriminatory action. The court sided with the Court of Appeals decision. This case matters because at times employers will seek to maximize profits while taking little consideration for the safety of their employees. This case is also critical because it clarifies the employee's limited rights under OSHA and the regulation created by the Secretary. OSHA ensures that employers provide a safe and hazardous-free work environment. Employees should feel safe from receiving any discrimination or reprimand from their employer when refusing to do work, as long as their beliefs of an unsafe work environment is justified and their actions are not ill intended. With the rise of COVID-19 cases, while trying to maintain safety in the workplace, in the case Doe versus Scalia, OSHA refused to treat any complaints regarding COVID-19 as an imminent danger complaint. This case was dismissed, but not without raising concerns that there's a lack of procedure to protect the employee if an OSHA inspector finds no imminent danger or takes too long to assert the situation, as it occurred in this case. COVID-19 has challenged the Department of Labor and its secretary on what accounts for work safety. Can the Secretary of Labor enact a vaccine mandate? The Supreme Court said it does not, since OSHA grants the power to set workplace safety standards, not public health measures. Whether it is to protect employees from pathogens like COVID-19 or from deteriorating weak structures, the Whirlpool versus Marshall case shed light on the power the employers and employees had when dealing with hazardous working environments. It laid out the base for future OSHA cases to fall back upon and use it as a clear reference to maintaining the safety of employees in the working environment. And here are my responses. Thank you.